Thursday, October 27th at 8:30. That might be
Yeah,
right.
that week for work, is there anything the 31st, the same time as today?
Yes, we can do Monday, October 31st at 8:30. October 31st at 8:30. And Mr. Mitchum, as I'm sure Mr. Butler has told you, or is going to tell you, the Department of Probation and Parole is going to come in and interview you and to prepare the PSI, which is a pre-sentence investigative report. It's a detailed written report that will go, and they'll ask you about your family, social, economic, and criminal background, and they'll prepare that report. So when they come to talk to you at the jail, make sure that you give them the information that they request so that the court and your attorney have the information at your sentencing hearing on October 31st. Okay, thank you.
Thank you, Judge.
Good morning and welcome to Brew and Sip, where you get your drip. We also have two locations, one at 505 West Broadway or meet us at 3800 Shepherdsville Road, where you can hold your business meeting or just meet with friends. Have a delicious cup of our drip as well as our smoked chicken salad. We hope to see you soon. Welcome back to the live.
Case the Commonwealth versus Vidal Berry, case number 16 CR 1099. We're here today for a revocation hearing. Counsel, would you please identify yourselves for the record?
Yeah, good morning, may it please the court, Robert McKnight on behalf of the Commonwealth. This morning is seated to my right, or standing to my right, is Officer Bigley on from Probation Board. Good morning, Your Honor.
Good morning, Your Honor. Anastasia McKettrick on behalf of Vidal Berry. Mr. Berry is seated to my left.
And have you reached an agreement, or would you like to have a hearing today?
Your Honor, with respect to that, I do understand that Mr. Novelist worked out a situation in which we would like to argue a motion that was filed, Your Honor, as I'm getting this case that's going to be up to speed. Should defense counsel like to make that argument, I would love to hear that argument, obviously, Your Honor, and make a counter argument to her request, Judge, if it pleases the court.
Okay. I know we're on for revocation, and it was the defendant's motion for home incarceration, but where are we with regard to the revocation?
Your Honor, with respect to the revocation hearing, we would like a sanction on that particular matter, Judge. We do understand he violated his HIP violation by walking outside on that matter. The Commonwealth would ask for revocation on that particular matter. However, if it pleases the court once again, we would like to hear that argument because, again, I was not provided that particular motion that defense counsel filed, Your Honor.
Okay, thank you. Ms. Manager?
Yes, Your Honor. As Mr. McKnight noted, Mr. Berry has been returned to LMDC on an HIP violation. The last time that we were in court back at the beginning of July, Mr. Berry could not be present. He had been taken to Peace Hospital after demonstrating acute mental health symptoms. It's been a long mental health history for Mr. Berry. It's had its highs and lows, and at that time he was at a particularly low point. So Peace Hospital was able to stabilize Mr. Berry, but it was not the type of long-term treatment that Mr. Berry really needs. Ms. Garrett with the Public Defender's Office has now been able to secure a bed for Mr. Berry at the VOA. So that has a bed date of August 31st. I would ask at this time for the court to allow Mr. Berry's release in anticipation of entering that VOA program. It would start as an intensive inpatient program that would allow Mr. Berry to really grapple with his mental health needs. And then later, as he progresses through the program and as he has the benefit of that long-term treatment, it will follow up with aftercare as Mr. Berry proceeds into the outpatient version of that program. So I can understand that the probation violations and now the HIP violation may be a concern to the court. That being said, the benefits of this VOA program are going to allow Mr. Berry to be maintained in the community, to be able to be supervised in the community moving forward. Mr. Berry also still has the support of St. John's Center for Homeless Men. Some of the employees from St. John's Center are present this morning, so they are aware of Mr. Berry's both mental health needs and his involvement in the court system and are absolutely willing to support him in both matters if the court is willing to consider Mr. Berry's release this morning.
The concern I have is he was gone on a bench warrant for quite some time in this case.
That is correct, Your Honor, and at that time, Mr. Berry did not have any kind of mental health treatment or any network to support him. That has changed now, and so I understand that Mr. Berry's history can be troubling when the court is looking at his ability to be maintained, his ability to continue to check in with the court or with the Office of Probation and Parole as needed. I would just ask that the court look at the difference in the support system that is available to Mr. Berry now and how that system is going to help his mental health status and bring him to a position where he is able to report in and check in as needed.
Yes, Your Honor, the Commonwealth will object to this particular matter, Judge. As Your Honor noted, the defendant bench warranted for close to 3 years on this matter. After looking at the file, there's also additional bench warrants as well, which is pretty concerning to the Commonwealth, which shows he cannot be managed in the community. Additionally, with respect to the HIP violation, he also has violations for testing positive for illegal substances, which gives concern to the Commonwealth. So we do believe, one, he cannot be managed in the community, and two, we do believe that this particular mental health situation the defense counsel mentioned will be best managed by the Department of Correction, Your Honor.
Okay. Looking back through his history, Mr. Berry has a troubling failure to appear for 3 years in the court, and his violation was absconding. So he was granted mercy by this court for a serious felony by being placed on diversion, and then he refused to report. And the case is old, but it's only old because we couldn't get it resolved because Mr. Berry wouldn't report to probation and parole and would not report to court. So he's been out on a bench warrant for 3 years. And the court still showed him mercy by putting him on home incarceration, and then he violated home incarceration. So I don't think that's a realistic option for him any longer. I want him to get the treatment that he needs. I want him to recover from whatever mental situation that he is undergoing, but I have to make sure that he's reporting as directed to probation and parole, and he's reporting as directed to court, and he's not doing either one of those things. And if we don't have any kind of monitoring of Mr. Berry, then there's no point in having probation and parole at all and putting somebody on supervision. So I can't, in good conscience, put him on home incarceration again now after 3 years of zero compliance with anything. So how would you like to proceed with his, I know the prosecution's making a motion to revoke him to perhaps incarcerate him for his sentence today. I don't know where we are with regard to that.
Your Honor, should it please the court, we would ask for full revocation with everything we noted before, Your Honor, at this time. I do understand he's backing down 3 years, Judge, and as Your Honor noted, and additionally, what I failed to mention is restitution on this matter that he has yet to pay on. So if Your Honor is ready to revoke this defendant, the Commonwealth will be ready to move forward on that as well, Your Honor.
So I'll back up to where I started. Would you like to have a hearing, or have you reached an agreement on this case?
We have not reached an agreement, Your Honor. I was not aware that this matter had been reassigned to Mr. McKnight until this morning. So while I reached out to the Commonwealth, I was reaching out to Mr. Noplet, and I don't think any of that information was relayed to Mr. McKnight.
So are you requesting a continuance? Or do you want to talk now, and then I can call you later on the docket if you want?
I would defer to Mr. McKnight if Mr. McKnight wants to resolve this morning after talking further with a few things. I think that we can.
Judge, he can talk briefly, but the Commonwealth will object to a continuance. So please record it, we can step out briefly and come back. But again, the Commonwealth will object to any continuance at this time, Judge.
Okay, thank you. I'll give you an opportunity to talk a little bit further, and then we'll call you back. Okay, and we've got Mr. Farah on Justin Henson. We're working on that case now. Good morning. On the record in the case of Commonwealth versus Justin Jacob Henson, case number 17 CR 3349. We're here for a sentencing hearing today. Counsel, would you please identify yourselves for the record?
Good morning, Your Honor. I'm on Tom for the Commonwealth.
Good morning, Judge Matt Fair on behalf of Justin Henson, who's seated to my left.
Good morning. And I know we're here for sentencing, and Mr. Henson's on diversion for child support issues. And the last time he was here, he stipulated to violating the terms of his diversion by failing to pay child support. And we continued it to today. Have you reached an agreement about sentencing, or how would you like to proceed today?
Your Honor, we have reached an agreement. I have conferenced with case with Mr. Farah. I have reviewed Mr. Henson's payment history since the last court day. He has been paying compliantly. He also made a lump sum payment of $500 that was agreed upon. Given the fact that Mr. Henson is now in compliance, and the fact that he did spend some time in custody on this case, on this MPR, I believe it was 31 days total. And as a sanction on that stipulation, Your Honor, the Commonwealth is going to recommend a credit time served sentence of 31 days, and Mr. Henson will be maintained on diversion, and as long as he's compliant, we won't need to come back on this case.
Okay, thank you. Mr. Farah?
Judge, I have nothing to add. That was the agreement.
So, Mr. Henson, I'm sure Mr. Farah has explained to you the tremendous benefit that you have by being able to remain on diversion, potentially getting your felony charges dismissed and expunged if you comply with the terms of your diversion. So the only way for you to get around this situation is you've got to pay your child support as directed. You decided to bring a person into the world, you have got to support that person financially. That's your obligation. And in other ways, hopefully also providing mentorship and fatherhood to the child that you brought into the world. So hopefully you comply going forward. Your sanction is 31 days, credit time served, 31 days for failing to pay child support. Hopefully you'll report as directed, pay your child support, and be involved in your child's life going forward so that we won't see you back in court anymore.
Thank you.
Thank you.
Thanks, Judge.
Thank you, Your Honor.
Mhm. We have Mr. Adams on the phone and Mr. Cunningham on the phone, so I think we're ready on Daniel Russelot.
Good morning, Your Honor. Chris Cunningham from the Commonwealth.
Hang on just a minute. The sheriff's bringing out Mr. Russell. The sheriff's bringing out Mr. Russell. Good morning. We're on the record in the case of the Commonwealth versus Daniel Eugene Rosselo, case number 21 CR 1817. We're here today for a pretrial conference. Counsel, would you please identify yourselves for the record?
Good morning, Mayor. Good morning, Mr. Counsel. Yes, good morning, my name is Mr. Russell.
And Mr. Russell, I'm seated in front of me. And what do you have to report to the court today? Mr. Kleinman, we'll start with you.
This is one co-defendant in a multiple co-defendant case, and Mr. Adams and I are talking to each other, and I'm trying to move forward on the co-defendants as best I can. So at this point in time, I would just ask the court for another pre-trial date, and I hope that something conclusive can come back sooner, but we're doing all we can at the moment.
Okay. What, is that there's two co-defendants in another division? What division is that pending in?
That's in Division 1, yeah.
Okay, thank you. Mr. Adams?
Objection, I agree with that.
All right. How about if you return Monday, October 31st at 8:30?
That's fine, Judge.
October 31st at 8:30. We will see you then. Thank you. Thank you.
Thank you.
Looks like we've got Nick Newman on the phone on Jamie Goodman. Are you ready on that now? Yes. Okay, call that next. Jamie Goodman, please. Good morning, we're on the record in the case of the Commonwealth versus Jamie Nikos Goodman, case number 22 CR 1375. We're here today for our first pretrial conference. Counsel, would you please identify yourselves for the record?
Good morning, Stacy Grieve, representing the Commonwealth, and with me today is Officer Burnett. He is the lead officer on the case.
And Mr. Goodman is seated in front of me. And what do you have to report to the court today? I know there is a motion to reinstate home incarceration. Mr. Grieve?
Yes, and the Commonwealth has made an initial filing of initial discovery response. However, it's not complete. There are a couple more items that I do need to file in discovery, but I believe the case is proceeding along. I was intending on speaking to Mr. Newman today about an offer, but I will put that in writing and send it over to him after today.
And in case you couldn't hear that, Mr. Newman, Ms. Grieve stated that discovery is ongoing. She's provided you with some discovery. She's going to provide you with more discovery. She was going to talk to you about an offer today. But since you're on the phone, she's going to go ahead and send that to you in writing. And what do you have to report to the court today?
Just that, yes, I sort of expect all that to be ongoing. The company will be in a better position to let the court know where we're headed and the court date. I did file a motion to get Mr. Goodman that date. I don't have a copy of the violation report with me, but from what I remember, it was mostly charging issues. He had to pick up any expenses. I don't believe there's any other type of violation. He's been in now for, I think, about 3 weeks. If the court would consider that suspension and placing it back on HIP, that would be our request.
Okay, thank you. Ms. Grieve?
The Commonwealth is not in agreement to the defendant being placed back on home incarceration. And we are not in agreement because of the serious nature of the offenses that he is facing in this indictment and the fact that he has 6 prior felony convictions on his record. So the Commonwealth feels he is a risk to, it's shown back, even though the violations is not committing a new offense, but they are significant violations. The fact that he was not taking serious the obligations that he should have been taking serious being on home incarceration. So we are not in agreement for him to be returned to home incarceration.
And Mr. Newman, Ms. Reeves stated that she does not agree to release him to home incarceration again. So of course it's up to the court to make the determination. And the situation that you're in, Mr. Goodman, is a difficult situation, and it's one of your own creation. You're facing very serious charges here. You have a terrible criminal history. You've got 6 prior felonies and an enormous number of misdemeanor offenses. You've got prior misdemeanor convictions. You've got prior felony convictions. You've got failures to appear, replete in your record. You have a sentence to incarceration. You have alcohol and substance abuse issues. And looking through your history, nowadays judges readily refer people to home incarceration as opposed to incarcerating them in the jail, which is what has happened to you. So when you were in district court, and I have your district court record here, you were sentenced to home incarceration. You violated your home incarceration. The district court judge re-referred you to the home incarceration. You violated your home incarceration again. The district court judge re-referred you to the home incarceration program again. You came here. This court put you on home incarceration. You violated your home incarceration again. So you're not taking your situation seriously, and you should be. You're facing very serious prison time on this case. And you've been given not the right, but the benefit to home incarceration repeatedly, and you repeatedly do not comply with home incarceration. So I can't in good conscience leave you on home incarceration any longer. So I'm gonna leave your bond where it is, and then we'll have a pre-trial conference. How about if you return on Tuesday, September 20th at 8:30? Actually, let me give you a little bit longer. That's not quite 30 days. Wednesday, September 28th at 8:30?
I anticipate being in trial that week. Could we go to the following week?
How about Monday, October 3rd at 8:30?
Yes, that's fine.
Does that work for you, Mr. Newman? Mr. Newman, October 3rd at 8:30?
Yes, Your Honor, that works.
Okay, October 3rd at 8:30. We will see you then.
Thank you, Your Honor.
You are the last party in the conference.
Maybe we excused your honor.
Yes, thank you. Let's see, and we've got Mr. Daly on Richard Reeser and Aaron Langley. Ready to call Mr. Reeser?
Yes, Your Honor. Your Honor, I have to go to the police chief.
You can hand it to the sheriff. morning, we're on the record in the case of the Commonwealth versus Richard Dwayne Reeser, case number 21 CR 1159. We're here today for a pre-trial conference, but I've just been handed plea documents up here. Counsel, would you please state your appearances for the record?
Good morning, Your Honor. Andrew Daly for the Commonwealth.
I'm Erin Langley on behalf of Mr. Richard Reeser. He's present and seated to my left, Your Honor.
Would you please state the Commonwealth's offer for the record?
Yes, Your Honor. The Commonwealth will move to dismiss count 1 of the indictment receiving stolen property over $10,000. On plead guilty to count 3, which is the only other count remaining as to Mr. Reeser. Criminal trespass in the 3rd degree. The Commonwealth will recommend a $250 fine. Recommend that be conditionally discharged for a period of 1 year. And Judge, if the court will recall, Mr. Reeser's co-defendant, Charles Hayes, already pled guilty, and that's the reason for the dismissal of the RSP charge.
Thank you. And Ms. Langley, I know you've been here on many occasions with Mr. Reeser. Do you believe you had a sufficient opportunity to explain to him what his constitutional rights are, the nature of the charges pending against him, and any defenses he may have to the indictment?
Yes, Your Honor.
Do you believe he has the capacity to make a knowing and voluntary plea?
Yes, Your Honor.
Will his plea be consistent with your recommendations as counsel?
Yes, Your Honor.
Thank you. Mr. Reeser, I have a number of questions I need to ask you to make sure there's a factual basis for your plea and that you can knowingly and voluntarily enter a plea. Before I ask you any questions, I have to swear you under oath, so would you please raise your right hand? Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Would you please state your full name for the record?
Richard Dwayne Reeser.
What is your date of birth?
2792,
What are the last 4 digits of your social security number?
4091,
What is your home address?
601 Revolutionary Road, Apartment 2.
And the zip code there is 40214?
Yes, ma'am.
What's your telephone number?
502-658-2710.
2710.
Yes, ma'am.
Are you the same Richard Dwayne Reeser named in the indictment for the charges pending before this court?
Yes, ma'am.
Have you had enough time to discuss your case with your attorney?
Yes, ma'am.
Are you satisfied with her advice?
Yes, ma'am.
If at any time you have any questions or you don't understand something, let me know. I'll let you speak with her privately at any time.
Yes, ma'am.
What is the highest level of education you've achieved?
GED.
So I can assume you can speak and understand and read and write the English language.
Yes, ma'am.
The reason I'm asking you that is I have 2 documents up here. You've got copies in front of you. I have a motion to enter a guilty plea and the Commonwealth's offer on a plea of guilty. Did you read each one of those documents?
Yes, ma'am.
Did you understand all of the terms and conditions used in those documents?
Yes, ma'am.
Did you go over everything in each one of those documents carefully with your attorney?
Yes, ma'am.
Is that your signature that appears on them?
Yes, ma'am.
Are you under the influence of any alcohol, drugs, narcotics, anything that would affect your thinking today? Have you ever been treated for any mental or emotional problems?
No, ma'am.
Have you ever been found by a court of law to be incompetent to stand trial?
No, ma'am.
Do you understand you don't have to plead guilty?
Yes, ma'am.
Do you understand that even now, as we're speaking, you still have a constitutional right to remain silent? You can exercise that right at any time, and I won't ask you any more questions.
Yes, ma'am.
Do you understand that you have the right to an attorney throughout these proceedings, and you will not be deprived of your attorney at any time for any reason?
Yes, ma'am.
Do you understand that instead of pleading guilty, you have the right to have a jury trial on the charges that you're facing?
Yes, ma'am.
If we had a trial, it would be the prosecutor's burden to prove to the jury beyond a reasonable doubt that you're guilty.
Yes, ma'am.
And if we had that trial, your attorney would be there with you to help you question or cross-examine any of the proof, evidence, or witnesses that the prosecutor has against you.
Yes, ma'am.
She would also be there with you to help you present your own facts, evidence, and witnesses to the jury. You could even testify on your own behalf if you wanted to.
Yes, ma'am.
However, you would not be required to testify. If you chose not to, your silence could not be used against you as evidence of your guilt.
Yes, ma'am.
Do you understand, if we were to have a trial and the jury found you guilty, you could appeal the decision to a higher court?
Yes, ma'am.
However, by pleading guilty and having this court sentence you pursuant to your plea agreement, you cannot appeal this decision.
Yes, ma'am.
So then you understand that by pleading guilty, you're waiving all of the rights that the court has been discussing with you today, except for your right to an attorney.
Yes, ma'am.
And as I'm sure she explained to you, and as these guilty plea forms discuss, if the court accepts your plea on this amended misdemeanor, you could potentially get the charges dismissed and expunged, depending upon what your prior record is, as well as your future course of conduct.
Yes, ma'am.
Has anyone threatened you, coerced you, forced you in any way to plead guilty?
No, ma'am.
Other than the recommendations of the prosecutor, has anyone promised you anything to make you plead
No,
guilty?
ma'am.
Do you know what you're doing here today, and are you doing this of your own free will?
Yes, ma'am.
I'm going to read you the facts of the case. They're written on the offer that you signed. The facts state, on or about February 20th, 2021 in Jefferson County, Kentucky, The above-named defendant was found to be in a restricted area without permission. Those facts that are written there that I just read out loud, is that what you did?
Yes, ma'am.
Is there anything written there that I read that's not accurate?
No, ma'am.
Is there anything about the proceedings today you do not understand?
No, ma'am.
Do you have any questions for the court, or would you like to speak privately with your attorney for any reason?
No, ma'am.
How do you plead to the charge of criminal trespass third?
Guilty.
I believe there is a factual basis for your plea and that you can knowingly and voluntarily enter a plea. And as the prosecutor said, your co-defendant, Charles Thomas Hayes, has accepted responsibility for the felony charges against you. So those charges are going to be dismissed against you today. And on your misdemeanor charge that you've just pleaded guilty to, it's going to be a $250 fine that will be conditionally discharged as long as you comply with the law going forward, which means you can't have any, not just convictions, but citations, arrests, or violations within the next year. So make sure that you do not. If you do, the prosecution can make a motion to have you pay a fine in the next year if you are alleged to have committed any future criminal offenses. So hopefully you'll remain law-abiding going forward, and we won't see you back in court anymore. Thank you.
Thank you.
Good morning and welcome to Brew and Sip, where you get your drip. We also have two locations, one at 505 West Broadway or meet us at 3800 Shepherdsville Road, where you can hold your business meeting or just meet with friends. Have a delicious cup of our drip as well as our smoked chicken salad. We hope to see you soon. Welcome back to the live.
I'm gonna do what my granddaddy taught me to do. Stand up for family. Fight back. Because we've been in the perspective for too long.
They don't expect that. We're not gonna have our kids marching. This is it.
Once and for all!
Justice for Patrick! Justice for Patrick! Justice for Patrick!
As a black man, I stand up for black women.
I don't want to say another motherfucking name! Kanye Jordan! 400 years later, not a damn thing changed!
I stand up for black women because it's what I'm supposed to do.
It's all one fight. The same people that suppress the vote, they'll suppress your living rate.
It's standing up for freedom, a freedom that knows action, a love that is in action.
Enough is enough!
I'm not sleeping and I'm not done until we get justice. Ain't no telling, people don't stop. Where's got to go? Hey, hey! Oh, oh! Let's go to where's got to go?
Why is everybody, why is the police fighting against us, but they're supposed to be helping us? That doesn't make sense.
If black women don't do it, then it don't get done. That's what I'm hearing.
When I say gun, you say no.
Don't forget what we did today. Today is history. Don't just go home and say, hey, let me post it. Live it. We just have to be stubborn enough. We just have to be strong enough. We just have to be relentless.